we're now streaming. Okay.
Yes, we are.
Hello, everyone. Thank you for joining me and agreeing to do this. I think we're going to be able to give a lot of valuable information for New York, New Jersey, and Pennsylvania. Ade, do you want to introduce yourself?
Hi, Stephanie. First of all, thank you for the invite. This is your brainchild, and I'm really excited to be a part of it. Thanks for thinking of me.
I'm glad you agreed.
My name is Adelola Sherilyn Dow. Everybody calls me Ade or Sherilyn, and I am the sole member and owner of the law offices of Adelola Sherilyn Dow in Staten Island, New York. I am a matrimonial and family court litigator. I am also involved in bringing appeals to the second and first departments in the state of New York. It's nice to be here.
Thanks. And Rebecca?
Hi, I'm Rebecca Levin. I am a partner at Journer Law Group. We're a group of 3 attorneys. We practice in primarily Pennsylvania, although we do practice in South Jersey as well. And so I handle family law cases. Also part of my practice is ART and assisted reproduction.
Great. And my name is Stephanie Hunnell. I own the Hunnell Law Group in Asbury Park, New Jersey. I've been in family law for about 16 years now. And my practice is primarily litigation related to family law, but we also do a little bit of real estate, which is what the other attorney in my office does. So I wanted to start us off talking to everybody a little bit about whether or not our courts are open, and whether they're doing business. How does that look from one state to the next? So at least I think, talking off camera, I think New Jersey is in a much better position than Pennsylvania, New York right now. So New Jersey, we actually got up and running pretty quickly in a matter of a couple weeks with an electronic filing system called JEDS. So pro se litigants and attorneys can file online for family court matters. They can pay online if they're filing a motion with a credit card. So it's not the best process. We're not even sure sometimes if things are actually filed when we upload them, but at least there's a mechanism for things to get to the courthouse, which wasn't necessarily the case before. New Jersey courts are also allowing electronic signatures for things that they wouldn't normally. So normally you have to have an original signing for a complaint, but now we're saying, nope, that's now been relaxed. So we'll see how that goes. What about you, Ade? What's going on in New York?
Yeah, so New Jersey is definitely a lot more open than New York is. And so with respect to Supreme Court, there are no new non-essential filings. So if you need to file for divorce, or if you need to file a modification on custody, child support, etc., you cannot do that in the state of New York unless there is an emergency that really is life or death, or if there are COVID involved restrictions with respect to your custody or visitation issue that you want to file. So no new divorces, no new regular visitation cases. Orders of protection can be filed because those are emergency issues. Orders of any kind of injunction that you need to be filed can be done. Emergency surrogate court work, so with respect to guardianships and any kind of mental health, mental hygiene stuff, that can be filed. Regular child support applications are not being taken. Unlike New Jersey, where people are allowed to argue motions, etc., virtually, we are not doing that. However, Supreme Court is allowing cases that are already in the pipeline. And what that means is that if you have a Supreme Court case, you have to file what's called an RJI to get a judge actually assigned to your case, and you pay another fee for that to get the judge assigned. Yeah, it's a little ridiculous, especially because in these times, people don't just have money just to be shelling out for this and that. But that's the way New York works. The fact that you filed your case does not get you a judge assigned, and so you have to pay for one to be. If your case is already assigned to a judge, judges are holding conferences with regards to matters. So if there are issues with discovery, which is the exchange of financial information, if there are financial issues, the judges are having conferences. Judges in family court, which is where we file our cases where people have not been married or are married or were married and don't want to go to Supreme Court, Those cases are being conferenced slowly but surely in Staten Island. There is a central location email for filing your family court cases, and I have that email address live on my website if anybody in New York needs to find it. But New York courts are somewhat restricted right now if your case is not already in the pipeline.
Okay. Rebecca, what about over in Pennsylvania?
Yeah, so New Jersey sounds like a dream right now because
and I didn't mention also the Zoom. You did mention that today, but we do have Zoom conferences, trials, motion hearings, and that kind of stuff is going on as well. So sorry, Rebecca, I cut you off.
No problem, no problem. Yeah, so in Pennsylvania, we have, you know, a statewide order that courts are officially closed to the public. Each county can decide how they want to interpret that order and what an essential function is for that particular court. And so we don't have uniformity among our courts with regard to any set procedure for child support or any other family law applications. And so what we are seeing I practice primarily in Philadelphia, and then there are the 5 surrounding counties. And so what we're seeing is guidance from each county providing what their procedure is and what they are considering emergent filings and what they're willing to hear or not hear. So Philadelphia is primarily closed for everything except emergency protection from abuse and emergency custody filing in terms of what you can have a judge make a decision on. In terms of paper filings, you can mail your filing to the court. You will not, you know, we have not seen people getting a timestamp back that their filing has been docketed. However, for support in particular, we have a system called PA Skidoo, and you can go online as a pro se or as an attorney and go to the system and file a child support modification and get some confirmation that you have filed something. Nothing is being scheduled at this time in Philadelphia in particular. In some of the surrounding counties, you might get a conference for support. However, for the most part, there aren't any hearings. So you can establish a retroactivity date, a date back to which support would be modified, but you will not actually see a change in your order until things reopen.
So, Rebecca, one of the questions that we got in advance from someone was, what are we doing for the non-custodial parents, which I am assuming means modification applications if people are, lost their job. So you're saying that you might be able to file, but you're not getting a hearing.
Right. And I certainly would recommend filing because, any change goes retroactive to when it's filed. We have not received any guidance that rule would be suspended. And I think practically, if someone waited to file until courts reopened, and then we're asking for an earlier date, traditionally that's, in other circumstances where someone loses a job or has a loss of income, it goes retroactivity to when they ask the court to take action. And so in this circumstance, I would say definitely file, save what you send. If you're using the online system, that's probably the best because you'll actually get some sort of electronic notification that you filed something. If you're mailing something to the court, if you can't get onto the online system for whatever reason and you're sending something to the court, definitely make a copy, send it with some sort of tracking. Don't send it with tracking that needs to be signed for though, but send it with some sort of tracking so that you can, make your best argument for having a date retroactive to when you filed. And then certainly aside from filing, we're hoping that, custodial and non-custodial parents are where they can working together to find solutions. And so while the courts aren't open, if they're, if the other parent or the other parent's attorney is open to having a conversation, really that's the best. Because I think, if you file something and you don't get a hearing till 6 months down the line, that parent who might have a child in their household, half the time, 40% of the time, it's going to really affect their child's quality of life And then the other parent might find that they've received a lot of support that they're going to have to pay back. And so
Right.
they should be planning for that as well.
Mhm.
Right.
How about in New York, Ade?
Yeah, it's great that Rebecca's talking about retroactivity, because that is definitely going to be one of the primary issues for us in New York, especially because unlike both New Jersey and Pennsylvania, our courts are not receiving documents that it doesn't believe to be essential. And the way the judges have been describing essential is that somebody's life or limb has to be in jeopardy, or you have to be in jeopardy of not actually seeing your child. And so child support applications, and also maintenance, which New Jersey calls alimony, and we call spousal maintenance or spousal support, is another issue. And if you have lost your job or you have your hours severely cut down, the retroactivity piece of this is going to play a large role. Our courts and our legislature has not indicated whether our strict rule on retroactivity, which is exactly the same as New Jersey and exactly the same as Pennsylvania's, the data filing, nobody's told us whether that rule is going to be relaxed. And I would think that the longer this crisis continues, the more likely it would be to be relaxed, but we really don't have any kind of idea on the horizon yet as to whether that's true. So as Stephanie and I were talking about yesterday, one of those arguments is going to have to be, especially if you have support that includes payment for third parties who may not be rendering their services right now, such as childcare or daycare or any kind of after school type activities. People are going to have to start arguing that to give the custodial parent this money when they were not receiving the service would be tantamount to giving them way too much, and it would be unfair. In the law, we call that unjust enrichment. That's the fancy word for saying that. But I will tell you that it's going to be extremely imperative for anybody who needs to file to have their documents at the ready. If you're going to be filing with an attorney, most of us are around accepting new clients and able to help you get your documents done. If you're going to be filing as a pro se litigant, again, I have links to pro se forms on my website. You're going to want to get those documents done ASAP and have your supporting financials ready, so that as soon as you hear that the courts are accepting unessential or non-essential filings, you can file that right away, so that you're lessening the time where you're leaving yourself open on the retroactivity issue.
Yeah, absolutely. I think if you don't mind, posting underneath the video links to the websites and any forms that you have or anything that you think's of value to people, after we're done or before or while we're doing it, it's up to you. But I think that can be really helpful for people. I was just going to mention, if anybody is getting any value out of this as a live, if you can tag people, if you think that somebody that it has some child support issues, make sure you like this video and tag them so they can get the information. Go ahead, Rebecca. Sorry.
Oh yeah, what I was going to say is the issue of payments to third parties is really interesting, and that's something where if you have a support matter in effect, and that's an issue where your daycare, private, mostly daycare, probably most private schools are functioning somehow remotely, and tuition hasn't been suspended for most private schools. But for childcare, daycare, babysitters that aren't providing normal services in Pennsylvania, that can be inside the order, meaning that it's part of what's wage attached, or it can be outside the order where it's paid in proportion to income. Outside the order, certainly both people are not paying it. Inside the order is what's going to be a problem, because that's where it's coming out of the paycheck automatically. And if you can work it out, reach out to your co-parent or reach out to an attorney if you have an attorney involved in your case to address the payments to third parties, because certainly, courts are going to be very overwhelmed with a number of applications, and addressing any overpayments for childcare is going to be a process that, if you're involving an attorney, it's going to be, costly, and it would be much better to handle it upfront now, rather than, get in line with all the support modifications and other issues that the court's going to need to take its resources to. So that's something that can easily be resolved by stipulation.
Right.
Yeah,
I would completely agree. I'm sorry, Stephanie.
That's okay. No, go ahead.
I would completely agree. You know, it's during this time, whether it's for child support or, you know, visitation, it is so imperative for everyone to try to cross those lines, however afraid they may have been in the past, but to try to cross those lines so that your child or your children can be the beneficiaries of your goodwill towards each other.
Absolutely.
If you know that, you know, your son or daughter isn't in daycare right now, then, you know, having that consideration to the non-custodial parent to say, listen, don't worry about that. We'll work out something later, and submit it to the court if we need to. I know that, you know, Becky's not in, you know, childcare. I know that Mikey's not doing XYZ, you know, a latchkey. So don't pay that right now. You know, that will go a long way towards your bottom line for your immediate pocketbooks, right? And wallets, and also towards the furthering of a fruitful relationship between yourself and your co-parent.
Yeah. I mean, it's also, I mean, you also save money if you have to get an attorney involved, or even just the filing fees sometimes, to get to court, if you can make these modifications yourself. And I think everybody should understand that when you have a court order, that's your order and that's your default position. But if you are able to modify that by agreement, put it in writing, you have an agreement, this is how we're modifying it, there's absolutely nothing wrong with that. You're not bound by that order if both of you agree to make a change. And especially under these circumstances when we don't know when things are going to open back up again, you know, hopefully the middle of next month or something. But I think even after things open up, it's probably going to be on a rolling basis. And the court system is going to be overwhelmed with everything that wasn't happening in these last couple of months because of this. So, I mean, I think mediation is absolutely imperative if you have the ability to do that.
Yeah, I was just going to talking about mediation. That's one of the services that my firm provides, and that's something that could be particularly helpful, especially with regard to child support. While there are a lot of calculators that you could find online, it won't necessarily have the nuances. Most attorneys, I have software, that is very similar, to the court software that will tell you exactly what that number should be. And so a mediator could really be helpful because they will be able to, gather your income information, and then run the guidelines, as a neutral and say what the most, appropriate number is based on the circumstance.
Yep, absolutely. A little bit about modifications in New Jersey. Just like Pennsylvania, New York, we have the anti-retroactivity statute that says that they're not supposed to adjust child support up to the limited circumstances. There's a couple of exceptions to that. But normally, the date of filing is the date that you're getting your retroactive support to. On top of that, we also say that if you want to change, it has to be not temporary. So, I mean, this is pretty much the definition of temporary, but it's such an extreme circumstance that we've never really had before. I can't imagine a court saying you're not going to get some relief. Even if it's just a temporary suspension, if it's, it really just is going to depend on the circumstances. But we were talking about this yesterday, and kind of the same opinion as Rebecca, but if you can file now so you have that date preserved. There's a statute in New Jersey also that allows you to send a letter, and then if you file within 45 days, you can kind of tack on that retroactivity. So if you send a letter and say, I'm trying to negotiate child support with you, I'm no longer working, I haven't gotten unemployment, or whatever the circumstances are, if we can't resolve this, then we can file our application within that 45-day period, and hopefully the courts are back up and running completely by then. If not, even if you file some application that's not necessarily perfect because you can't afford an attorney and you're filing the forms on your own, I do think that it still should be filed. Also, you guys mentioned about child support, the daycare inside the order and outside the order. So we tend in New Jersey, the judges tend anyway, to want everything in like one easy lump sum, throw it in the child support guidelines. We're going to spit out a number and this is your child support number. So some people are having their wages garnished, or they're going to have their unemployment check garnished, and it's going to be based on that total number, which might have the daycare in it. So, I mean, that I think there's more of an argument to say that child daycare component should be out completely, if you're not using that daycare service. I think you and I, Ade, were talking, correct me if I'm wrong, but we're saying something about a mom not wanting to give up that money because she was like, well, I've been spending all day with the child. That was us that were
Yes.
they were
Yes,
saying,
we
no,
were
no,
talking about
I'm now the daycare, so I deserve to get that extra money.
Yeah, we were talking about that. That was
Okay.
an argument that an adversary of mine made the other day. And, he said, but, mom is spending more money on food and more money on entertaining the child. And I couldn't quite wrap my head around that because, even if that were the case, as the mom of two little kids, they really don't cost that much to eat one extra meal at my house. I mean, it's, my daughter sometimes could be a little bit extra, but it's really not, to the point of spending an extra, in this person's case, $800 a month to feed the child. So yeah, I don't think that argument is going to work. We in New York don't have that 45-day rule, which is fabulous for New Jersey. We don't have that. And so even if you're trying to work that out, you're not going to have that retroactivity. But the interesting thing is about this temporary versus permanent hardship. And, we saw a lot of this. All of us were practicing during Sandy as well. Mm-hmm. So, especially down the shore where Stephanie is and Staten Island, where I am, which was very hard hit. We saw a lot of people who were out of work and could not go back to their capacities at whatever jobs they had. And our courts were somewhat more lenient. And I'm hoping that that's the case for COVID-19, which I think may in some cases be more long lasting with respect to individual companies' abilities to bring people back to work. Mm-hmm. So, that's, I think that this will, a lot of interesting case law may come out of this actually. Even if it's just at the lower level courts because people don't have the money to pop it up to appeals, that it may be a very interesting argument and very interesting time to see whether these judges are going to say, hey, listen, this is really an anomaly type situation, and we have to give people a certain degree of relief. The other thing that New York does have to offer is that our rules were changed recently. And when I say recently, it was 2010, which is recent in the law.
Yeah,
where people are relying upon cases from 40 and 50 years ago. But our statute was changed to allow for modifications to happen upon the passage of 3 years, change of circumstances, and also for 15% plus or minus change in incomes. So that is something that people can hang their hat on with respect to modifications here in New York, which they may not have in the other states in the tri-state area.
Mm-hmm. Yeah, we definitely don't have a set number as far as a percentage or a dollar amount that says that now you're entitled to a change. You have to file your application, and if that particular judge in that particular county thinks that that is a significant enough number to not even just to change, but to even review your child support. So that's just the first step, is you have to prove to the judge that you have a change of circumstances that warrants a review. And then once they review it, they might still say, we're still not going to change it. It's not significant enough. So it really, it depends. So that's great that you guys have that in New York.
Yeah. In Pennsylvania, I think, the interesting thing about temporary circumstances is that certainly, very well, by the time you get a court date, hopefully, your financial circumstance will be the same as what it originally was. And we'll be talking about a period of 3, 6, a period for many, different types of jobs. Mm-hmm. For example, maybe like a hairdresser will, business will come back. Everyone's going to be going to the hairdresser.
Yeah.
Might be making more money for the first month.
But there's going to be that interim gap, which will really be interesting. The other thing, I'm really why I can't encourage, coming up with solutions by agreement now more enough, is that in Pennsylvania, we have a multi-tiered system procedurally in how these cases are heard. So in most counties, you're going to go and you're going to initially meet with a conference officer. And that person's going to take information that they see on your pay stubs and put it into the support calculator and tell you what your new support number is. And so they're not necessarily, dealing with these interim issues. Well, something changed for a period of 3 months, and now it's back to this. That's going to be something that they're not charged with deciding. And so in most counties, the level after that is a master. And so a master is not a judge. It's usually an attorney who has some authority to make decisions, and they will have a hearing in front of them and decide the case based on what they see. And then if you don't like their decision, you can basically file what are called exceptions to a judge. And so it's really going to be at that middle level where we're, as attorneys, able to make these arguments about, okay, well, maybe something was different for this period of 6 months and now it's back. What should do? But that's going to take at least 2 times going to court to have that type of issue.
Wow.
By a master. And so really, that could all be avoided by really, looking to cooperative solutions, either directly with the assistance of counsel or with the assistance of a mediator.
Mm-hmm.
Yeah.
The other question, we had another question posted, and it asks, how are judges responding to applications for reductions in support due to the current status of many? And by many, I'm assuming they mean, being furloughed, businesses are shuttered and those kind of things. So, I don't know that we actually have an answer to that. I think the
answer is that we don't have an answer to that, that only filings are being accepted. We are not having hearings on these issues. Mm-hmm. And so that remains to be seen. I think that I would expect most, judges, masters will be sympathetic. And that's certainly how I would advise, a parent receiving support, that if someone has a loss of income during this period, that, is likely, to not be questioned by a judge or a master. And so I think they're going to be probably more sympathetic than in other circumstances.
Right.
I agree.
Yeah, I think the same thing as well. We have no idea what the judges are doing. And again, it depends on which judge you get before. There's not really any uniformity prior to this. So we can't really predict that there's going to be uniformity after this with certain judges doing different things. But I think we also have to be mindful when we're talking about modifications or even suspensions or something like that. The flip side is the enforcement, that the person needs support. That person who also needs child support might have had a reduction of income also. So if we're talking about 2 people who are now furloughed and are, receiving unemployment or not receiving unemployment, or their boss got a PPP loan and they're getting paid based on 20 hours a week or something. The reality is it's hitting both sides of the fence. It's not just people that have lost their jobs that are paying support. It's also the people receiving support that need that money because the child is with them most of the time.
That's something else. Oh, go ahead.
That's absolutely right. And Rebecca, that's where a statement that you made earlier comes in, where the custodial parent could be concerned. Wait, am I going to have to give any of this money back? Mm-hmm. And generally, the way our laws are written right now in all of our states, the short answer would be no. But it's going to really, and I don't, like you said, Stephanie, I don't really know how much flexibility these judges are going to have with respect to that particular rule, which is statutory. And which comes from federal law, but that you're probably not going to be likely to have to return any of the money that's for basic child support. You may be in a situation where you have to return money for a third party for incidents that are inside of the order, like Rebecca was saying earlier. Yes. But if your co-parent is no longer paying, right? And you're not getting any money from that person. And I have a case like this right now where my client said, hey, look, but I know this person is getting unemployment and they're supposed to be getting unemployment at the elevated level, right? Which is that additional $600 that the feds are contributing. But they're still not paying me anything. The good thing for you is that you will be able to have that money enforced retroactively. And if that person has no basis for not providing you with this income, because let's face it, in a lot of situations, if the person is actually getting the enhanced unemployment, they may be making more on the enhanced unemployment than they were making before they were terminated, or or their job was eliminated. So you need to make sure if your account is going to be managed or is being managed by SCU in New York, or Stephanie, you'll talk about probation in Jersey. Those entities keep a record of exactly how much the person owes. If your money is being provided to you outside of an agency, it is going to be so imperative for you to keep records of everything that you are owed. If it's add-ons for medical expenses or childcare that you actually are paying because you are an essential worker and therefore childcare is necessary for you, then you're going to need to keep adequate records, especially if that money is direct pay. It's going to be your burden to show the court that you are owed what you say you're owed.
Yep. Yeah, there were two issues that came to mind as we were talking. One was sort of, while you may not be made to pay back money for support that you've already received, if the court says that, yes, there was retroactive adjustment, what we will see a lot is a credit on arrears. And so what that could mean is that, if the court says you've overpaid your child support by $4,000, someone then, if it's not, could not send in, not pay support for a number of months until that credit's used up. So that's why it's really important to plan ahead. The other thing, that Ade touched on, some was, wage attachment, that if someone's lost their job and receiving unemployment, their paycheck isn't going to be attached, automatically, or if they have reduced income, you may not be getting the full amount of support because a wage attachment will only take up to a certain percentage of someone's net income. And so parents who are receiving support are going to possibly, be seeing changes in the cash flow that they get, even if it's wage attached, because there may not be as much money in a paycheck or no paycheck to attach it to.
We have, I've just talked to a couple of people with unemployment. So they're just now receiving their very first unemployment check, and they've been out of work for over a month now. They are bogged down over there. So if you lose your job and that wage garnishment is no longer attached to the paycheck, here in New Jersey, the probation department will catch up and they will attach your unemployment benefits. But the reality, I think, if it's taking a month for them to even process the first check, the chances of them processing that wage garnishment any quicker is probably very, very slim. So, communication is key. If you're not receiving support, let them know. And maybe the person didn't even realize. I thought that I've had people that actually genuinely think that the child support's going to come out of my unemployment check now. It might not have, and they don't even think anything of it.
Right.
So if you're communicating and say, by the way, I haven't gotten any support, it may be just like an innocent thing where they do want to pay you, but they just didn't even realize that it wasn't taken out already. And plus, once you have the money in your bank account, it's a lot harder to give it up if you're used to having it garnished because you don't see it being taken away. And you think, oh my gosh, I have this amount of money and I have expenses too. And I have my child more often than I used to have them. So I think that I have to be mindful of that. So the probation department, I don't even honestly know if the probation department is up and running here in New Jersey. I would assume that they are because the courts are pretty much, everybody working remotely. So I imagine that would apply to the probation department. I'm just not 100% certain.
Yeah, I know here in New York, SCU is not taking any walk-ins. Generally, you can go down to Center Street or your local courthouse has a SCU location. You can go in and ask for modifications and, things like that. But there is no such thing going on right now in New York. There is an email address that you can email. I wish anybody who does try to email them very good luck, but I do understand that they are taking telephone calls. Your wait time is going to be horrendous. I experienced crazy wait times with my local bank. I can only imagine what the wait times would be for SCU. Stephanie and Rebecca, what are your state thresholds for wage garnishment percentage levels? Because in New York, if you're in arrears and you have another family to support, your max is 55% of your net available income. And if you don't have another family to support, it's 65% of your net available income, which can leave people with very little money to live on.
Yeah, ours is at 60%, and I don't think they care if you have another family to support or not. It's 60% of your wages are going to be garnished, up to the amount of your child support or child support arrears. And I do know in New Jersey also, if you're a couple of payments behind, they can issue a bench warrant for your arrest. If you have $1,000 or more of child support arrears, they report that as a judgment against you. Anything even more significant, they also can flag your passport so you can't travel. If you are not paying, there's a driver's license. They can suspend your driver's license. So there's a lot of mechanisms for enforcement. And I can imagine that over the last months, if people haven't been paying just because they literally have no ability to do so, I don't know what's happening with them. Because I didn't really prepare this question, so I didn't look into probation to see what they're doing.
Rebecca, what about you?
I believe that when I last looked, it was 50% of the net that they would take.
Either way, it's a significant amount of money for people who are earning less or almost nothing.
Yeah, it is a significant number, and I mean they're just taking it, so there's no choice. You don't get to. Now on that point,
that's what I was just reminded. I knew I wanted to say something about tax intercepts.
Yes, that's what I was just going to bring up.
Yes, okay.
Yep, the stimulus checks. So they're allowed to take those stimulus checks if you have back child support.
Yes. So this is a pro for custodial parents who are owed money, and it is a certain con for non-custodial parents and their spouses, because it's not just the non-custodial's part of the stimulus that's going to be taken. It's generally the entire thing, just like it would be in a refund situation.
Right. And I want to make sure that everybody understands, because I've had this conversation with multiple people. The stimulus check is an advance on your future refund. So you're not getting this, it's not like it's free money and now you're getting this extra money, that's going to pay some child support or whatever you're going to do. It's a advance on your future refund. So I mean, it's still your money, and it's your spouse's money, like you said. So I think people have to be careful this is kind of a side note, but in my opinion, people have to be very careful in their filings for 2020 and make sure that they have their elections done correctly, so they don't have a huge refund that now gets reimbursed.
Right. None of us are CPAs or accountants, so don't.
No, not at all. I'm not giving you advice.
But as
if it were me
and family law attorneys, we deal with people's tax issues all of the time as a part of our litigation and practice. And you definitely have to be very careful. And quite frankly, I mean, I said something about this on my Facebook page recently, where, we have all of this marketing coming at us. Oh, spend your tax money here. Oh, spend your stimulus check here. Yeah, you might not want to do that. Even if you get it, you might want to just hold on to that. Because we really don't know how long this is going to be, and we don't know what the implications of it will be long run. And you might just need that money for your rainy day. If your rainy day is not today and you've been able to weather this, wonderful, but you may still want to set that aside.
Yeah, and I had a client ask me about what right their ex or the other parent of their child has to their stimulus check. If you are filing it on your individual return that you did not file a joint return with this person, and that's not what your stimulus check is based on, that is your check. I've had questions about, my ex is saying that they should get part of this check. It's going to you. It's not, anything that the non-custodial parent should be entitled to unless it's filed, it was received based on a joint return.
Right. And
that's right.
there's a little gray area there too, because some people are getting divorced through this. They might have filed a complaint, they might not have filed their complaint yet, but it's based on, if you haven't filed your 2019 taxes, it's based on your address and the direct deposit account that existed in 2018. So if you're getting that stimulus check, it gets direct deposited into somebody else's account, you're going to have to fight to get that back unless you're communicating correctly. I mean, there's that issue, and who does it belong to, because it was deposited into that account. I mean, that'll be another little nuanced thing that we'll have to talk about on another.
Yeah, because when it's in advance on your future refund, really it needs to be paired correctly, and that's going to be a whole nother issue for another day.
Yeah.
Right.
And if one's making a lot of money, one's not making a lot of money, who took the children as deductions for that year? Because there's also that $500 per child component as well.
Right.
Yep.
Right. And a lot of our orders, it's alternated.
Right.
What I haven't seen, well, yeah, I mean, it really could be hit or miss, in terms of whether it was your year to claim a child. You might get a windfall based on that, because, your filing status really changes what you'll be entitled to.
Right. We have a question posted. Are they able to take the entire stimulus check? So if there's a significant amount of arrears, I think they can take the entire thing up to the amount of arrears. So if you owe $3,000 in arrears, they're going to take the entire $1,200. I don't see any reason why they wouldn't.
Right.
It's not the same as taking like the 60% for the actual child support.
Right. It's more like a tax intercept, same thing, where if you were owed a tax refund and you had outstanding child support, that can be intercepted and paid to the other parent. And so that's how I'm seeing this treated as well.
Yeah, exactly. I agree with that. So, if you are at that point where you're going to get $1,200 and you owe your child's custodial parent $2,400, you're not going to get a stimulus check. Right.
I mean, and that's great for the non-custodial parent. I think it's a little bit rough if you really, really need that check. I mean, some people who live paycheck to paycheck and aren't getting a paycheck for a couple of months, even weeks, frankly, it could be a huge problem. And that $1,200 means a lot as far as feeding anybody who's in that person's household.
Absolutely.
So, yeah, it's rough. We have another.
But I'll tell you, depending upon the amount of money that we're all arguing about, like, what Rebecca said, what you, Stephanie, have said, communication is going to be key, because you really, even though we all love to make a living, you really don't want to be spending so much more money in counsel fees arguing about getting $1,200 back. So communicate, talk to each other. At some point, this person, you could communicate with this person enough to have a baby with them.
Yep.
So, harken back to those days, not physically, but mentally, and talk to the person.
Yeah, because at the end of the day, you have to co-parent with this person as well. And
That's
so
right.
even if it's not a dollar for dollar in litigation, it can really, I've, seen people who have not had good communication skills in general, having communication improved, during this emergency, because, there's not another choice right now in many circumstances, but it's really something that hopefully people will take forward and, really cooperate and, have goodwill to the other parent of their child to get through this difficult time for everybody, find solutions, and hopefully, improve a relationship with a co-parent going forward, as opposed to, okay, well, you kept my check when you knew I didn't have a job and I couldn't buy food. That can really sour a relationship. And so I think it's really a critical time to take a look, at yourself and what you want your relationship to be with your co-parent, even if you despise that person for what your child is going to be seeing or experiencing when they're in that household.
And our kids take cues from us. So if we're okay with something and we're, communicating and working together, the child and the children are going to only benefit from seeing that relationship. Like right now is one of the most difficult times that our not just our country, the world is experiencing. And people have a lot of anxiety and, there's a lot of feelings going around, and the kids are feeling all of this too. So they don't need that added pressure of the two of you fighting over a $1,200 stimulus check. Like that's something you guys really should be able to figure out. And I know I say that kind of, that's the way it should be. Maybe people need to work together and communicate. And I do realize that there are relationships that are already so beyond repair that you'll fight over $5, let alone, $1,200. But I think that you need to put that aside and really take to heart that kids are already suffering enough, anxiety with what's going on. They can't see their friends, and depending on their age, don't even really understand why this is happening. So, I don't understand why it's happening.
Right. I don't know if I really want to understand, because then I might know too much. But depending on your school of thought as to why this is happening. But as lawyers, the other thing that I think is really important for us to educate people on is when you cannot do this alone, or when you should not do this alone with respect to modifications. Mm-hmm. And for me, in New York, I think if you have a business, all right, if you are a contractor, 1099, but it's really that you have a business and you're working for other people and that comprises your business, mm-hmm. you may not want to do this modification alone. You may want to file it immediately if you can, and then have an attorney come in and help you get those documents right, because your situation is going to be totally different from somebody who has a W-2 and a paycheck.
That's a very good point. And we did talk about this a little bit the other day as well. Because you might not be able to file right now because you just can't afford to hire. Rewind. You might not be able to retain an attorney to file right now, right, because you just don't have the resources, or you're wanting to make sure you keep all of the resources that you do have, because we don't know how long this is happening and you want to keep your business up and running. But yeah, file something, and then, we can come back in and either file an amended pleading, or figure it out to make sure that you have the retroactivity date. But also there is a lot that goes into modifications for businesses, because it's not, again, like you said, mm-hmm. it's not a W-2 where you can say, here's what my income is. We're talking bank statements, invoices, depending on the type of job that you're doing, because the court is going to want you to prove that you really did have a decrease in income, and it's not just you saying that you did.
Right.
I have another question. It says typically before 60 to 90 days before the child's 19th birthday, we receive a letter to review the child support status to either continue paying or not, based on college enrollment status, etc. I think there's, okay. So I think what she's talking about, there's a letter. So New Jersey changed the emancipation statute a couple of years ago. And so you get a letter that says you're going to be entitled to modification, or they're going to be kicked off the probation system. That letter is very confusing when people get that letter. But you're still entitled to child support if the child is going to college. A couple other reasons, but so I think the question is, there is a second part. Sorry. Sorry. Okay. 60 to 90 days prior to the child's 19th birthday, we usually receive a letter to either continue support or not, based on college enrollment status, but we haven't received anything yet. Is this on hold? Oh, yes, probably.
Yeah, and I would say in Pennsylvania, we do not have support for children in college. That support ends at 18 or graduation from high school. And so if you know that that's your situation, same thing as before. I did this for a family the other day. They had, two children. One was graduating, one was, still a minor and entitled to support. And so we knew that the number was going to be changing. We just, figured out what the new number would be based on one child as opposed to two, and did a stipulation, which when the court opens up their mail, and processes everything, it will be there with the, correct retroactivity date, and it'll make things a lot more easy. So for things like that, there's a change, something that that, in particular, a child is aging out of child support, that's something that we can resolve now and have it waiting for the court when they
Right.
are
And
processing everything.
Yep, and emancipation is one of the exceptions to the anti-retroactivity statute. So if a child is emancipated during this and you file an application 2 months from now, you could still get the reduction upon the emancipation date. So that's that as well.
And in New York, our emancipation age is 21, 21. No matter whether the child is in college or not.
Really?
There are some exceptions with respect to that. So if the child is working and they're fully supporting, these are other exceptions. But even if the child is not in college, there is still a very good argument for child support because that's what our statute says, 21, and there's no
That's
mention.
very interesting. I never knew that about
I
New
didn't
York.
know that either.
Yeah, and so this is why sometimes people negotiate different ages for emancipation based upon events that change. And I know New Jersey, you can do the same thing. You can do just about anything you want to in an agreement, so long as it's
Absolutely
not against public policy and illegal. But yeah.
One you brought up, Rebecca, that kind of triggered something in my mind is if we have these, somebody's working, so they're continuing to have their wages garnished. I think there's probably going to be an issue as well as if there was a reduction because of emancipation or some other change of circumstance, they're not going to be able to do that until their wages are going to continue to be garnished until we can get into court to get an order to remove the garnishment, because you can't just say, now we agreed that my children are now emancipated or my last child is emancipated, child support should be zero. That's still going to be garnished. So
yeah, that's why a parent who's receiving support really should be planning, especially in that circumstance, for if there's an overpayment of support on their account. That's not free money.
Right.
Whether it's that support's not going to be paid for several months, that if it's a child that's emancipated, and it will be money that could have to be paid back. So really, I would plan for that if I'm a parent receiving support.
Yes, that's right. I have a few clients who were supposed to have their court dates during this, and in the interim, their children have emancipated, and that's absolutely right. And at least in the state of New York, that money, even if it's dispersed to now SCU actually has a way of looking to see whether people are emancipated. So SCU may not actually be delivering all of this money to the custodial parents if you have one child on the order. But if you have more than one child on the order, and it's a wage garnishment order going through SCU, you should set that money aside, because if the application has already been filed, the fact that that COVID has caused the courts to be closed is not going to, correlate into you getting free money. So
right.
Please set it aside. Don't create a problem for yourself later, because some of our judges will issue judgments against you, money judgments against you. And if that's the case, that money judgment is filed with the county clerk and it does go on your credit report. You really don't want to be messing with that type of thing at this point.
I have a case right now that we received an order from a judge here in New Jersey, essentially emancipating one child and determining that child support should be reduced significantly for the other child because of some government benefits that the person I represent is on Social Security disability. And because that was never taken into account when they calculated child support. So as we all know, that could be a significant drop. So you have one emancipation and then you have the government benefits that the child's receiving on the child support guideline. Unfortunately, the judge said you have to mediate and figure out what you want to do with the child support number. So we have an order prior to this. I mean, just like the week that we closed the courts, we got this order. And we did have a phone conference about it. The other side and I have not come to an agreement because the mom had been receiving apparently benefits for the children for at least 8 years now.
Oh my goodness.
Yeah, so it's a significant issue. But his wages or his benefits are still being garnished, and he's bringing in like $400 a month right now. And we have no agreement to have that money paid back yet. So, I mean, I hope that this person is getting good advice and is putting that money into an account, because this is not more free money that she's getting. Even if we don't go retroactive to the date of disability, there's, you know, some significant money just going forward since March that's going to have to be paid back.
Wow. And see that really, I don't know about Pennsylvania, Rebecca, but that really does hallmark of stark difference in the two states. We are neighbors right across the water from each other, but New York does not have SSD derivative benefits impact the non-custodial parent amount of support. Those SSD benefits are considered to be the child's money, and they have absolutely no impact upon the child support amount.
Wow.
So if you are, and we get calls about that all the time. So if you are in the middle of getting your Social Security benefits during this time point, and somehow they you do or did receive notice right before this even that you were granted your Social Security and your child will have benefits, that is not going to help your child support obligation in the state of New York.
That's interesting. Wow.
Yeah, it's kind of a windfall
today.
What'd you say?
I said I learned 2 new things today.
Oh, I come to bring the knowledge.
I love it.
I love these nuances. Yeah.
Me too. I mean, I've never practiced in New York. Obviously, I'm a New Jersey attorney. I do have a Pennsylvania license, but I've also never practiced there. And it's interesting to see the differences between the 3 states, I should say.
Yeah.
Yeah. We're at like 3:58 now, so I guess we should probably wrap this up. I don't know if you have anything else to add. I don't have any questions here, but if either of you have anything to add.
No, I think this was great. Certainly, if we have any people who have been listening to this on Facebook Live or listen to it later and, have questions, they can certainly, post them on Facebook. They can, I'm sure, email any of us, at our offices. And if there's any, further, topics that, today was on child support. I know we touched a little bit about what our courts are hearing on other issues, but be it, custody or emergent applications for protection from abuse, we're happy to answer those questions as well.
Yep, absolutely.
If this was beneficial to you all, let us know. Maybe we'll do it again.
Yeah, different topic.
Yeah, it was a lot of fun. It was I really I learned some new things too. So
did I.
And when we find out the answers as our courts reopen, we'll definitely,
Absolutely. And I will look into the probation to find out if probation is doing anything as far as enforcement goes, because there was also a question online about that. And Ade, if you can post a link to your website with the forms, that would be perfect.
I sure will. Ladies, it was a pleasure talking with you all, and
nice
hopefully everybody gained some value.
You as well. And I'm trying to see where the button is.